Recording also. Congratulations again. My name is Rebecca Tinder. I'm the West Virginia We the People Coordinator and the Facilitator for Unit 4. Our last person to admit has now joined, as well as our judges are here, and they will introduce themselves. The students will introduce themselves, and then they will introduce a teacher, and we will begin.
Okay, great. Well, congratulations on making it this far. And we, as Rebecca said, we'll introduce yourselves, have you introduce yourselves and your teacher, and then we'll turn to the business at hand. My name is Joe Stewart. I teach in the political science department at Clemson University in South Carolina. Been involved with the program for a number of years. I always look forward to this because it's a great opportunity to talk with you and have a good conversation about the Constitution and what you've learned about it. Relax. We're going to have a lot of fun this afternoon. I'll turn it over to my fellow judges to introduce themselves.
So good afternoon. My name is Lynn Simons, and I'm the Chief Judge of the Second Judicial District Court of the state of Nevada, and I was with Unit 6 all weekend, and so I'm excited to hear a new unit, and I welcome you and the suspects on the table behind you, one of which I think is Ruth Bader Ginsburg. But relax, take a deep breath, and I'm looking forward to enjoying the conversation.
Good to see you all. I'm Hank Chambers, law professor here at the University of Richmond. I've seen y'all somewhere before, so it's good to see y'all again. We'll have a good conversation this afternoon. I look forward to it.
Good afternoon.
Please introduce yourselves and your teacher.
Good afternoon. We're students from the Virginia Wildcard team at Douglas Southwell Freeman High School in Henrico, Virginia. Our teacher's Mr. Rob Peck. I'm Jack Haranchar.
I'm Claire Morris.
And I'm Cameron Cavender. We're excited for our conversation with you guys today.
Great. Okay, we will turn to question 2 then, and I will read the question. The president ought to communicate such papers as the public good would permit and ought to refuse those the disclosure of which would injure the public. Do you agree or disagree that the executive can withhold or disclose information at her or his discretion? To what extent, if any, has the claim of executive privilege expanded presidential power since its inception? Are the constitutional powers that enable the other 2 branches to counter executive privilege claims sufficient? Why or why not? You may begin.
Separation of powers is an essential and inherent part of the United States 3-branch system of government. Built into the system was a set of checks and balances to distribute power. One of these checks is executive privilege, defined as the ability of the president to, quote, withhold documents or information in his possession or in the possession of the executive branch from compulsory process of the legislative or judicial branch of the government.
As the head of the executive, the president carries an expectation of transparency within office in order to maintain trust and consent of the governed. However, just as the founders valued secrecy at the Constitutional Convention, there is a need for some privacy in order for the president to be effective in office. As unanimously ruled in Nixon v. United States, the valid need for protection of communications between high government officials and those who advise and assist them in the performance of their manifold duties is too plain to require further discussion. Furthermore, Article 2, Section 2 of the Constitution states that the president is the commander-in-chief of the Army and Navy of the United States. This title implies not only the power to direct armed forces, but also the power to make decisions regarding the safety of the people and the country as a whole. This can include withholding information from the public in order to maintain confidentiality and to avoid panic.
However, while we agree that executive privilege is an important power, it is not unlimited. The president is not above the law, and as shown in the case of Clinton v. Jones, which investigated Bill Clinton's affair with Monica Lewinsky, information that is simply embarrassing or shows misconduct is not protected.
Executive privilege has undeniably expanded since the founding of our country. Presidents have been claiming executive privilege since the first presidency, but the precedent didn't emerge until 1958, when Attorney General William P. Rogers cited Jefferson's remarks in his diary. The term itself was coined by Eisenhower, who used the power an estimated 44 times while in office. He expanded the coverage of the claim to national security issues in United States v. Reynolds and interpersonal communication when he forbade his advisors from testifying in the McCarthy hearings.
Additionally, there are instances where executive privilege has been abused and expanded too far, most notably in the Nixon administration's infamous Watergate scandal. In United States v. Nixon, the court ruled that the president's claim of confidentiality of executive communications, quote, cannot prevail over the fundamental demands of due process of law and the fair administration of criminal justice.
It is essential that the other branches of government hold checks on executive privilege in order to prevent the dominance of the executive. Yet, because the powers of the president are vague and poorly defined, it is difficult to ascertain where the boundaries exist when it comes to the powers of the president. Historically, the Supreme Court has ruled that executive privilege can be overcome by the legislature showing sufficient need for the information and an inability to obtain it elsewhere. Recently, the court has granted greater deference to the executive by forcing Congress to present significant proof that the information they are seeking is a necessity. In the case Trump v. Masters, consolidated with Trump v. Deutsche Bank, the court proposed a test to determine what information must be handed over by the president. The four-prong test requires the court to determine whether the legislative purpose requires the president, whether the breadth of the subpoena is necessary for the case, whether the subpoena advances a, quote, valid legislative purpose, and whether the burden of the subpoena is placed directly on the president.
These recent cases highlight that the legislative branch's power to make and oversee the enforcement of their laws alone are not significant enough claims against executive privilege. However, cases such as US v. Nixon and Clinton v. Jones show that Congress's power to investigate the executive for impeachment can be significant enough to make a claim against executive privilege.
So while our panel supports the president's ability to claim executive privilege, we recognize the necessary check on the power that the other branches must hold and would advocate for enumerated limitations on the power. Thank you. We stand ready for your questions.
Thank you. The original quote talks about documents. We have moved from the age of documents to the age of tweets. How does that affect the executive privilege, or has it?
I think this is similar to President Trump's actions on January 6th. Whenever he used a burner phone, he intended to circumvent the traditional proceedings of the president to have everything documented and saved within the executive branch. So I think tweeting is very different because there is obviously not the same veil of secrecy or privacy over social media.
So the president is commander-in-chief, and that suggests that he has some right to keep information quiet. But doesn't Congress have a role in foreign policy as well that requires that they be given a lot of information?
Sure. This can actually be seen very early in our country's history when the Jay Treaty was signed. This was a very unpopular treaty that Washington created, and Congress had asked to see the documents that went into making this. And Washington invoked executive privilege, but eventually gave the documents over to the Senate because the Senate in particular has the ability to advise and consent for treaties. Important.
So that being said, on the topic of treaties, so the House in this instance would have limited authority over those documents and a limited claim to those documents because they have less of a role or not much of a role at all in regards to treaties. So the Senate in this case would have a valid claim to that. And we also believe that Congress's role, in order for them to perform their duties as efficiently and effectively as possible, they need to be able to obtain the information needed to pass legislation and perform their duties as best they can.
I agree with Cameron's statement on this. There's certainly some information that, if possible, should be divulged to Congress, but might not the general public. And we can see that in the way that some national security hearings are held private and out of the public eye because the information contained within might be pertinent to legislation, but not something that we can share with the world as a whole.
So why did the House of Representatives think that they needed the information that underlie the Jay Treaty?
So I think this may have been due to the fact that this was a very new sort of issue. Executive privilege, the term hadn't exactly been used yet, but Washington was one that sort of set that precedent. And having the executive being able to keep secrets, there's always going to be a pushback from the different branches. I mean, this was intended in the founding of our nation through Federalist 51 talks about ambition counteracting ambition, and it only makes sense for them to want to push back on different powers in order to keep that balance.
And as my colleague stated, the issue with the Jay Treaty was fairly new, or was at the beginning of the birth of executive privilege, the first case being the St. Clair military disaster, and then the Jay Treaty shortly following. Then after that, another instance is Aaron Burr and Thomas Jefferson. Their little dispute, Aaron Burr wanted some letters from Jefferson, and Jefferson claimed executive privilege over that. And we kind of see this idea of executive privilege evolving throughout American history. And so while it was relatively new at that point, I think it's been a little bit more defined as American history has progressed.
Okay, thank you.
And so, there's the age-old idea that power corrupts and absolute power absolutely corrupts. So in the instance that you have absolute corruption, are the checks that you've identified sufficient, or is there some other type of evolution that needs to occur with Congress or the judiciary to put the executive branch in check in that instance?
I certainly believe the checks that we have in place now are moderately sufficient, as we see in the cases investigating presidential wrongdoing, such as Nixon v. US and Clinton v. Jones. When the cases have gotten to the Supreme Court, the information that was necessary was deemed pertinent enough to a case to overcome executive privilege.
And we see the courts playing a very limited role in limiting executive privilege, because they can't really reach down and take any case they want and point out anything that the president's doing wrong unless it's brought to them. They kind of need an invitation to rule on the matter. My colleague mentioned if it's subsequently tied to it, they could fit a ruling in there about executive privilege, but the only real reason that they can rule on the issue is if someone comes to them and brings a case to their bench.
And another issue with having the judicial system take this is these hearings, and these basically they're held in contempt of Congress, and being able to determine what is national security, if it's a good claim or not, can take a really long time. An example would be Obama in the Fast and Furious case claimed executive privilege for national security reasons. And this case took 4 years to be able to be ruled on in the courts. And this is a really big problem because justice delayed, one could argue, is justice denied. And there's actually right now in Congress, it's passed in the House, but an act called the Protect Our Democracy Act, which has I think it's Title 7, with a clause stating that these sort of executive privilege cases need to be fast tracked within the Supreme Court in order to avoid this issue.
And I think a check that goes relatively unnoticed is the check that the people hold in this instance. The people ultimately have the power to elect a different president when the 4 years is up. And I think obviously they can make their voices heard on how they think a president's performing and what they're doing. But ultimately, it's up to the people to elect who they think best fits the role of president. And if they're unhappy with what a president's doing, they can certainly not elect them back into office.
What do you do in a president's second term?
Can you specify a little bit there?
Yeah, you can't run for a third term. So what do you do in a president's second term in terms of not having the chance to vote him out?
So I think in a president's second term, I think the power of the people is a little bit diminished here. As my previous point of being able to vote them out is no longer valid, they can still kind of make their voices heard in other ways. But I think in these cases, during a second term, we lean more on the legislative and judicial branches.
I would agree with my colleague. I think Congress would play a really important role. They do have the ability, let's say a president's calling executive privilege or they're not responding to a subpoena. They have the ability to craft laws and legislature to kind of circumvent and go around the president. An example of this would be during the Nixon administration, when Nixon was refusing to hand over the tapes. Congress actually passed a law called the Presidential Records and Material Preservation Act, which basically was directed at Nixon and forced him to turn over those tapes and recordings so that they could proceed with their investigation.
Okay, as I understand it, your argument for the executive privilege is that it's necessary for presidential effectiveness in office. Why should we limit ourselves to foreign policy, national defense, national security? Don't we want an effective presidency in other policy areas?
I think when you start to branch out beyond those specific issues, you tend to fall into maybe the executive branch as a whole, the DOJ and other organizations that might fall under the scope of the executive branch, but not necessarily the president. And I don't know if we should be applying executive privilege to those parts of the executive branch.
And we see in Federalist 70, the idea of needing energy in the executive. And a key part of this is secrecy. And I think our main point behind this is that issues of national security and information potentially injuring to the public are the main focus of what executive privilege should protect. Certainly it can extend elsewhere, but then you get into the question of, are you extending it too far? And certainly if it's covering up any wrongdoing by the executive, that's unacceptable.
And you can actually see it extending beyond national security and other issues through the presidential communications privilege, which basically says that the president is able to communicate with his advisors freely without any worry of public backlash, because that's protected.
What do you think? Go
Oh, sorry,
ahead. No, you go.
Can the president do his job or her job without executive privilege?
I would argue that the president cannot do his job well without executive privilege, because if his day-to-day communications, especially with his advisors, are subject to the scrutiny of the millions of individuals that are within the United States and the national security information is public, then it'll just become too political.
Yeah, I would agree with my colleague. I think if you make all the actions and words of the president public, it greatly limits what they can say without worrying about that political backlash and their political reputation. I think this would be a similar instance to Congress with C-SPAN. We see Congress people being overly partisan and kind of having to watch what they say, pander to their voter base due to everything they do, or almost everything they do, being televised. And I think the president having that veil of secrecy allows him to do his job most effectively.
Okay, well, thank you. Very good job. We want to give you some comments. I very much enjoyed our conversation today, and it was a fairly broad-ranging conversation because you had so many different ideas and good ideas. I wish we'd had more time to challenge some of those. It kind of how many people really watch C-SPAN, but that's the ratings aren't great as far as I can tell. But I've liked all the different avenues you took us down, and I thought you responded to questions well. You tied it back into various important things like Federalist 70. It's always good to hear the phrase "justice delayed is justice denied." But all in all, it's very good conversation. Thank you very much.
Thank you.
Thank you.
Thank you.
I really enjoyed it. And I think that you appreciate that a hard line is difficult in this situation. And much of it, of the support that you gave, really did involve some persons that may have been perceived as corrupt a bit. I think that your viewpoint on the judiciary's role was interesting. That, the time involved is first hindsight, actually saying, oh, I want the documents here, we're going to issue this subpoena. Then you have the either provide the documents or other electronically stored information, and then no, I'm not going to. So then you have the contempt power, and then ultimately you have judicial review. So it may take a long time for the court, but it may take a long time to get there. And I think that your idea about fast tracking those cases, similar to like preliminary injunctions, was a wise one. So I enjoyed it. I also enjoyed some of the how you developed, you kind of wove through different acts, and it showed that you had this bank of knowledge behind you, but that you were holding some back in your testimony, and you were giving it to us in a thoughtful and at the right time methodology, and I appreciate that. Well done.
Thank you.
There's a lot of good stuff to talk about. I won't talk about all of it. I'll just say that there was a lot of good stuff in there. A couple things you want to consider is, as you noted, transparency is important, but there does need to be some forms of privacy. Where you draw that line is real tough, and y'all saw that it was tough to draw that line. One thing I do want y'all to sort of consider moving forward is if you were a congressperson and you wanted information, how might you go about getting it? All right, what kind of soft levers do you have to push on the presidency? That's one. And number two, what kind of information do you need in order to do their job? One of the reasons why I asked you about the Jay Treaty and why the House thought that they needed the information is that, yeah, the House is not involved in treaty making, but the House does have to appropriate money that may be necessary for the things that the treaty puts in place. So in some respects, Congress has a lot of responsibility, and they need some information that the president does not want them to have. But from an overall perspective, I think you did a really strong job. You have obviously a very, very deep knowledge base, and that's the kind of thing we like to see. So good work, and maybe I'll see you across town pretty soon.
Thank you.